based on National House Buyers Association, HBA Malaysia, they have received thousands of complaints annually from home buyers on various types of defects. Generally, the main ones are pattern defects and latent defects. The major key component that differentiates between these two is visibility of the defect. The pattern defect can be clearly seen, especially during the inspection, while latent is subtler and more hidden than may be seen after so many years. A research study reported that poor workmanship, material of construction, faulty design, irregular maintenance, and moisture problem may cause defects in residential buildings. Defects give a diverse negative consequences on the occupants of the house and general public, for instance, serious health problems, mental illness, and dissatisfaction. We have chosen the ARA Joint Management Body versus Mammoth Land and Development Sdn Bhd under the Malayan Law Journal Unreported MLJU as our case study on defects. Briefly, in October 2016, ARA Joint Management, a management body of the residential community of ARA Bangsa, sued Mammoth Land and Development Sdn Bhd. The plaintiff claimed that the defendant has failed to rectify the water leakage and penetration issue. These two issues have been encountered by the resident, which they have informed the defendants since the handover period in December 2007.
Plaintiff claim. The plaintiff had highlighted that the defendant had acknowledged the issue, and through the defendant representative, they have promised to rectify the water leakage and penetration issue. However, the defendant failed, neglected, and refused to do so. As today, the plaintiff say that they still suffer from the issue. The water leakage and penetration wherein water seeped through the reinforced concrete slab and beam of the ground floor, which caused the water stain marks and damaged plaster ceiling, and water intrusion into the concrete elements, which led to corrosion of rebars and ultimately to the spalling of concrete. Besides, the plaintiff also discovered cracks along secondary beams supporting the swimming pool from unit number 23 to number 28 in 2014. The defects were then assessed by the DPI consult at Sdn Bhd hired by the plaintiff and had identified that the cracks were due to shear bond failure where the main beams are not secured well during construction. Next, defense of the defendant. The defendant claimed and denied that the plaintiff's action in tort is backed by the Limitation Act 1953 and the allegation of negligence and the various representation made by the defendant through its representative. The defendant highlighted that the claim is frivolous, scandalous, and vexatious, or an abuse of the process of the court. The defendant highlight that the plaintiff had slept on its right where they should take action earlier than that, which not until 8 years after its cause of action occurred. In addition, the action of defendant is exempted from any liability in relation to the defect as it is past the date of DLP and Limitation Act of 1953. Thus, the defendant highlighted that the plaintiff was not entitled to claim any defect from the defendant. Thus, the claim raised by the plaintiff has to be struck out. Pleading by plaintiff. As defended by the defendant that the claim made by the plaintiff was not liable, the plaintiff's stand is that the defendant is stopped from claiming that the plaintiff action herein is backed by Limitation Act 1953. The plaintiff highlighted that the issue was well aware by the defendant, as can be seen in the minute of the JMB's meeting, which was held on 5th December 2009. In the meeting on 2nd January and 6th March 2010, the representative of the defendant has highlighted that they will prioritize the rectification work. On 7 August 2010, the defendant informed them that they have completed rectifying their problem at the individuals and will continue the works at the common area. However, the works promised by the developer have been postponed until today. The plaintiff highlighted that If the developer did not make any promise from them, they might take action sooner. The defendant is also aware that the promise influences or causes the plaintiff to take legal action or delay in taking an actions against them. The plaintiff highlights that the defendant had clearly intended to cause or bait the plaintiff from commencing any legal action until 6 years after the limitation of acts and defect liability period had expired as referred to the recorded minute meetings.
As for the court held, the defendant argued that this is a clear-cut situation in which the plaintiff's claim should be dismissed. The defendant, relying on M. Bank and Berhad versus Abdul Aziz bin Hassan and Ars 2010, argued that the claim of the lawsuit should be dismissed, claiming that it was time-barred. This is due to the limitation having been set in accordance with the limitation of Act 1953. On the facts, the plaintiff contended and suggested that the discoverability rule should be used in this case. The discoverability rule, which states that the limitation period begins to run from the time the defect could have first been detected with reasonable diligence. To put it another way, the 6-year limitation period must begin when the cause of action arose, not when the alleged negligence was found. Only at trial where experts are called would we be able to determine when the cause of action arises in order to prevent the defense of limitation from being raised by the defendant against the plaintiff. The court then examined whether the doctrine of estoppel was applied and whether the promises given by the defendant prior prevented the plaintiff from proceeding to legal actions, as the defendant had mentioned before that the plaintiff should have taken action earlier. The court then agreed that to preclude the defendant from raising the defense of limitations against the plaintiff is a matter to be established at trial, where the plaintiff can cross-examine the defendant's representatives who are eligible to address the defects. In this case, the Court of Appeal should not have overturned the trial judge's finding of fact since the plaintiff had successfully proved estoppel. As a result, the court has dismissed the defendant's counterclaim against the plaintiff and held that the preferred test would be determined at trial.
Next, I will present regarding express term of this law case. This law case involved the ARA Joint Management Body versus Mammoth Land and Development Street Berhad 2017, where it involved a private project. This kind of issues has been covered in PAM Contract 2018 and had stated in Clause 15, which is practical completion and defect liability. Okay, so for this case, the most suitable clause is on clause 15.4, which is it talk about schedule of defects. So in these clauses it's explained about the defects that causes during the defect liability period, which is DLP. Defect shall be specified by the architect in a schedule which is shall delivered to the contractor not later than 14 days after DLP. The contractor shall make good within 28 days after receipt of the schedule of defects. Then, if failed to attend the defects, the employer may employ another person to rectify the defects, and all the costs incurred should be set off by the employer, which is under the clause 13.4. Not only that, but if the architect with the consent of the employer instruct the contractor to leave the defects, then appropriate deduction for such defect not made good shall be set off by the employer under clauses 13.42. In easy term, we can see at the flow below. The period for CPC until the expiry of DLP and is around 12 months only. Okay, so the next is the schedule of defect. It involves both listening defect where it is less than 14 days and making good defect around less than 28 days. Okay, so in this slide, it's explained about the relationship between PAM clause and the law case. In this case, the property was handed over to the plaintiff on December 14, 2007. And then the plaintiff state and claimed in the statement that all the issues had been acknowledged by the defendants during the DLP, which took place between December 2007 until December 2009. But the defendant postponed from taking any action and rectification works until it's exceeding the time period set by the Limitation Act 1953. Which is it's only 6 years as stated in Section 6 of the Limitation Act 1953, and because of it was expired in December 2013. Thank you.
In conclusion, defects are something that commonly happen in any construction projects. They are not avoidable in any circumstances due to nature or human error. The defects should be managed properly in every case according to the clauses stated in contracts, either PWD 203A or PAM 2018. All parties involved in this event must take part to ensure the flow of the problems can be handled efficiently. DLP is a period that is compulsory to follow until listing of defects and period of making good defects. The period depends on the contract use. There are several lessons learned from the law case in terms of professional practice. Regarding to the study, the plaintiff made a right call to report and acknowledge the developer about the latent defects, which were water leakage and penetration issues during the DLP. This suited the situation according to the clauses in PWD 203A, clauses 48.1A and 48.1B. The clauses explain all the defects must be made good when the complaint through written reports was noticed during stipulated time. Meanwhile, in PAM 2018, the clause that could be used is clause 15.4. Both contracts offer the opportunities for the developer and contractor to fix the defects caused during the period. However, the developer needs to repair the defects at their own expense because the clauses have been stated wholly in the contracts. First lesson to learn is every homeowner has right to list their defects on their projects. This is because the employer is entitled to claim and rectify the defects. Furthermore, every developer must be noted to every defect reported to them, hence instruct the contractor to fix the defects. This is compulsory for the developer because it is their obligation to do so. The defect must be made good until 30 days of the period in which they are made. If they fail to do so, the contractor developer must be ready for the consequences or even litigation by the employer. Moreover, any unreasonable reasons related to intent to cause or bait the employer from commencing any action and abuse of Limitation Act 1953 is unacceptable in the arguments. Lastly, to hire the building inspector and solicitor as an independent party, it's important to check the defects thoroughly and reducing any favoritism in valuing the problems. The application of clauses give chances to employer to list their defects and the contractor developer to fix the defects that occurred during the DLP. Defects have to be corrected within the period contained in the contract. The clauses avoid the contractor or developer to get sued and claimed by the employer due to breach of contract.